I mentioned yesterday that when we plan for a conference like this, we start about 4 months out. And we try to catch the issues that we think will be topical in April. If you saw the headlines this morning, one, a few pieces of paper from the Department of Justice Office of Legal Counsel were released by the administration before a judge in the ACLU lawsuit was going to order them released. That has to do with interrogation, which fits into our panel this morning. And you recall the panel yesterday, our first panel about surveillance, and we mentioned the headlines yesterday about the report that the NSA exceeded congressional limits. And you probably saw today's headline that the chair of the Senate Intelligence Committee is now going to hold hearings on that. So we can't get more topical than that. Our panel this morning, the first of the 3 panels for today, is going to focus on, I think, what is one of the most perplexing issues for the Obama administration. And that is simply developing a new paradigm for detaining alleged terrorists, whether they be at Guantanamo Bay or the next terrorist that we capture somewhere in the world, and also for that percentage of detainees for which there is some evidence of criminality. How are you going to prosecute them? And more importantly, where will you prosecute them? What forum will you use? Now, let me suggest to you that the choice of Guantanamo Bay was not an accident. The lawyers here know that following World War II, there was a very, very significant case called Johnson versus Eisentrager, in which case Justice Robert Jackson wrote an opinion, and he basically said, when you're dealing with individuals who are detained outside the United States, who have never been prosecuted in the United States, who are not United States citizens, who have never been in the United States, then they have absolutely no statutory or constitutional right to come into the courts of the United States. Now, that was existing legal precedent in 2001, and it's clear that the Bush administration attorneys, the legal advisors, said we need to find a place outside the United States to put these people. And Guantanamo Bay was the selection. Perhaps Diego Garcia might have been a second alternate, but Guantanamo Bay was the best choice, based on existing precedent. And what happened was, as you know, in 2004, the United States Supreme Court, in what was clearly a surprise to the Bush administration, looked at Guantanamo Bay, and it said, the circumstances of Guantanamo Bay are so unique, there is such military operational control over that facility, that Justice Stevens, writing for the court, said there should be at least statutory right. We are interpreting the habeas statute to allow those folks to come into our federal courts. That ruling lasted but 1 year. And then the United States Congress, in a statute called the Detainee Treatment Act, said to the court, we are amending the habeas statute. What you gave, the right to come into the courts, you gave last year, we are amending the statute to take it away. And of course, when you're not dealing with a constitutional issue, the Congress can legislatively overrule even the Supreme Court. Well, not to be deterred, the Supreme Court in 2006, the very next year, came back, and in one of the issues, in a case called Hamdan, the Supreme Court said, wait a minute, that act of Congress is only prospective. It only applies to the future filings. And all those court cases that were accumulating in the District of Columbia circuit are still alive and well. Congress then responds a second time in 2006 in what we call the Military Commissions Act, and it expanded the jurisdiction stripping provisions of the habeas statute and said, not only does it apply to anyone in detention by the United States anywhere in the world, not just Guantanamo Bay, but by the way, court, we're making it retroactive all the way back to 2001. And again, a statutory interpretation, the Congress could do that. And then, I think as most of you know, last summer, in a case, a very, very significant case called Boumediene, the United States Supreme Court for the first time said that those at Guantanamo Bay, and only those at Guantanamo Bay, had constitutional protection under the suspension clause. Constitutional protection. So Congress could not go back and change that. Thereafter started habeas cases at Guantanamo Bay regarding the Guantanamo detainees. And most recently, in the District of Columbia District Court, Judge Bates extended the ruling of the Supreme Court to cover 3 detainees at Bagram Air Base in Afghanistan who were non-Afghans and who had been captured outside of Afghanistan. I haven't heard yet. My suspicion is the United States government will appeal that to the Court of Appeals of the District of Columbia Circuit. And my guess is that the Circuit Court may overrule Judge Bates, and we can expect that case will go to the United States Supreme Court. In other words, how far does constitutional protection extend to a non-U.S. citizen, someone who's never been in the United States? It's a huge issue. That's detention. What about prosecution? Again, looking back to World War II, there was a military commission that was held involving 8 German saboteurs who had come into this country in Florida and Long Island to destroy defense facilities. They were captured. They were prosecuted by a military commission sitting in Washington, D.C. Supreme Court upheld the jurisdiction of that in a case called the Kieran case. That was the model for the Bush administration. And the military order that President Bush signed on the 13th of November of 2001 was virtually identical to the order that President Roosevelt signed in that German saboteur case in World War II. And so we had military commissions, and one of our panelists, General Altenburg, is very familiar with that, as I'll tell you in a minute. Military commissions that were haltingly moving forward at Guantanamo Bay until the Supreme Court in the Hamdan case in 2006 said not that those military commissions were unconstitutional, but that those military commissions at Guantanamo Bay violated 2 other provisions of law, provisions of the Uniform Code of Military Justice. For the military folks, Article 21 and Article 36B. So it was then left back to Congress to reconstitute the military commission system. It did it in 2006 in what we call the Military Commissions Act, and that's the current system that was ongoing at Guantanamo Bay that resulted in the military commission of Salim Hamdan and 2 others. And then, as you probably know, earlier this year, within a matter of days after President Obama took office, he issued an executive order that said we would close Guantanamo Bay no later than the 20th of January of 2010, and he also directed the Secretary of Defense, Secretary Gates, to suspend the military commissions, and they are suspended until the 20th of May of this year. So now, the question for this new administration is simply this. What do we do with those at Guantanamo Bay? Where do we put them? And also, for not all of them, but for those for which there is some evidence of crime, some violation of statute or the law of war, where do we prosecute them? That's the question that the panel this morning will be talking about. And let me go ahead and very briefly introduce them to you. And then I'll be conducting our panel in kind of a moderated discussion format. Rather than having each one speak for 15 minutes, we're going to kind of move back and forth. And because I know there's a division of issues on this panel, because that's why I chose them to come. Jonathan Hafetz, by the way, who flew in at 11:45 last night. ACLU, and they've got a lot of action going on with these memos being released, because they were the litigators in that. John is an attorney with the National Security Project of the ACLU, American Civil Liberties Union, and he's litigated many of the post 9/11 detainee cases. Most notably, John was the attorney representing a gentleman called El Mari. El Mari was the resident alien in the United States that was detained in South Carolina, and his case was about to be heard in the United States Supreme Court when the Obama administration directed that he be released and moved into the federal criminal courts, from whence he came. Actually, he was under indictment in Peoria, Illinois. John, before he was at ACLU, He directed the litigation for the Liberty and National Security Project, New York University's Brennan Center. I think many of you may be familiar with that. And I think John is obviously going to bring us a pure litigator's point of view with regard to these two issues of detention and prosecution. Commander Glenn Sulmasy is a judge advocate, but he's an associate professor of law at the U.S. Coast Guard Academy. And he's been on the faculty at the Coast Guard Academy since 2001, am I correct, Glenn?
Yes.
He teaches international law, constitutional law, criminal law. He publishes, he lectures widely on such issues as the law of war, conflict, international law, national security matters, and a very frequent commentator in both all three, print, radio, and television media. Major General John Altenburg, to my immediate left, retired Army judge advocate, served 28 years on active duty, a number of prestigious military assignments, including, upon retirement, the Deputy Judge Advocate General of the United States Army. For military folks, that's pretty high up, as you know. He is now with Greenberg Traurig, counsel, but for our purposes, and the reason why I wanted John to come down is, John was the convening authority for the military commission system at Guantanamo Bay before the Supreme Court struck it down. Matter of fact, John was there for a little less than 3 years until the Supreme Court ruled in the Hamdan case that that system was in violation of statute, and he left that position and was replaced by Susan Crawford upon the enactment of the Military Commissions Act by Congress. But John brings a perspective particularly about the prosecution aspect of what do we do with those detainees. So that's our panel, and I'm going to start out by asking all three of them a huge question. What do we do with the 242-odd folks at Guantanamo Bay? John, what do we do with those folks? Don't bring them to Durham, but what do we do with them?
Interesting that your first comment is a NIMBY approach. I think as a practical matter, we probably do have to close Guantanamo simply because it's acquired the reputation that it's acquired. But if you can strip away all the feelings and all the things that people in the international community have said about Guantanamo and look at the reality of Guantanamo, it's become a model prison. There's no better place for us to detain people like this. We've invested millions of dollars. It's secure, and none of the alternatives that I've heard discussed can match Guantanamo in terms of the quality of the security, in terms of the quality of the facility, in terms of the training of the guard force. And the only reason not to go back and revisit that decision and stay at Guantanamo is simply it's not worth the political hassle, the political capital that has to be expended to do that. People have such a wrong-headed notion of what Guantanamo is. And I'm not faulting, I'm certainly not faulting any institutions. If I were going to fault anybody, it would be some decisions that were made early in the administration in 2001 and 2002. But most of what people believe about Guantanamo is Camp X-ray, and they were out of Camp X-ray within a year. And when they see people in orange suits and cages, you know, it's just not the reality of what Guantanamo is. But it reminds me a little bit of, if you know anything about the Washington, D.C. area, it reminds me of Lorton. If you'd asked somebody 10 years ago, you ever want to buy a house in Lorton, Virginia, they'd have thought you were crazy because of the prison for the District of Columbia that was at Lorton. Now it's one of the most desirable places in all of Fairfax County. And just 10 years ago, people have said there's no way I would ever want to have a 22079 zip code for me, you know, in a Lorton, Virginia address. And so having said that, my own personal view, because I think I operate kind of pragmatically, and that I think that is the best place for them. I think back to President Clinton saying we're going to be out of Bosnia in 1 year. And nobody questions that now. Nobody goes back and says, boy, was he wrong about that, because everybody recognizes that what's happened in Bosnia has been positive for the world and positive for stability. and we need to be in Bosnia. The NATO forces and our forces need to be doing what they're doing. And so here we are, 14 years after the president said, I guarantee you we'll be out in 12 months. Nobody questions that. And it would be my hope, and it is just kind of a hope, that by the time we get close to January 20th or whatever the magic date is, that there'd be enough things happening in the world and at Guantanamo for the president to be able to say, I need more time, I want to look at this a little bit more, we're going to take some of these people and put them somewhere, but there's a certain number of these people we have to keep there, and that by that time, public opinion would have turned so much. He has such an edge in terms of the honeymoon and the grace that he's been given because of the positions that he's taken and all the positive things he's done since he took office, that I think he might earn enough capital to make that hard decision, that hard political decision.
Well, and the decision to close was done by executive order. The president can change the executive order if he
Right.
wants to. I guess it's a question of, is there the political will, and will it be accepted publicly if he does that? John, what do you think about this?
Well, I certainly think Guantanamo, it's correct, Guantanamo must be closed. It's become a symbol, rightly or wrongly, although I think largely rightly, of many of the abuses that were carried out after 9/11. And certainly, things have improved to some extent at Guantanamo in terms of the treatment of the detainees, but I take issue with, or not take issue, but would want to qualify the idea that it's a model prison. The fundamental problem today with Guantanamo is that it's a prison, and we're imprisoning people, still more than 200 people, without ever having charged or tried them. So you can compare it to a high security prison in the United States or a supermax prison, but the problem is we skipped a step, we skipped the most fundamental step. We've locked people up for going on 8 years without charging and trying them, essentially for what we're claiming is criminal conduct. Closing Guantanamo, the most important thing is not, I think, where prisoners are kept, but what process and what legal framework they're kept under. Simply closing Guantanamo and moving some detainees to the United States and detaining them without federal criminal trial is really kind of putting a Band-Aid, I think, on the larger problem. I mean, to me, the solution is that anyone at Guantanamo who is suspected of an act of terrorism or conspiring to commit an act of terrorism needs to be prosecuted in a federal court. And the other detainees should be, those who are not criminals after 8 years should be released, should be repatriated, sent home, or sent to a third country. I know that will require some political effort, but it must be done. And I think one of the important steps, if the United States is going to do that and is going to repatriate many of the detainees who the United States does not want to detain anymore, the United States needs to accept some small or some number of detainees. The most frequently talked about group is the Uyghurs. They're an ethnic group from northwestern China, Muslims, who the United States has, it's conceitedly picked up by mistake, is held for years without any basis to detain them, and there's their community that will accept and help them adjust if they're taken into the United States. So if the U.S. is going to solve the Guantanamo problem and you release those who it no longer wants to detain, it will need to shoulder some of the burden itself.
Glenn?
First, I have to state up front I'm here in my individual capacity, especially with a retired general sitting 2 steps away and several colonels and legal advisors to the State Department and whatnot, and ambassadors. I have to be careful. I'm in my individual capacity when I'm here. And I did want to thank Scott and Tiffany, and I think Donna's outside as well, for just a super conference so far. It's really an honor to be here, and yesterday afternoon was terrific as well when I did get in. I think what President Obama has to do, and we all know this, is to find that delicate balance between promoting national security and also promoting our commitment to human rights. Not an easy task. It wasn't an easy task for President Bush, and it's not for President Obama. I think the item we have to look at when we decide what to do with Guantanamo is recognize that those 2 concepts aren't necessarily mutually exclusive. They're actually compatible. They need to be worked together in a compromise, in a hybrid, in a third way alternative to best solve what we have ourselves trapped in right now, a paradigm of either using a pure law enforcement approach, using our civilian Article III courts to prosecute, try, detain these people, or to use the military commissions process, which, again, did not necessarily achieve its intended objectives. For whatever reasons, it was not successful. It has not been and is going to close. So when we look at it from that perspective, I suggest that there are really four ways, and I would recommend and encourage, and I do think embrace the idea of a multifaceted approach to how to best handle the closure of Guantanamo Bay. One is the diplomatic means. We have to do that. We have to engage in diplomacy and repatriate some folks. And actually, Berkeley Law School has out a recent study where they're talking about not only when we do go to repatriate them, but the United States is committed towards helping them adjust back to their new countries. If folks that are necessarily found to have been held without charge erroneously for 7 years, we have to find some way to allow them to get back into their countries and be resettled and repatriated successfully. The second option is civilian courts. Jonathan's right. Certainly, we have used them. I'm not in favor of that in most circumstances, but we have used them over the past few years, and Human Rights First has a documented history and analysis of the use of using civilian courts for trying terrorists, which is worthwhile to be looked at. Third, I'm not so certain that the 120-day suspension that the president is going to actually end the military commissions. I think he has 5 high-value detainees there that he may use the military commissions potentially for those that are there. End it after that, perhaps just for the 5, but as a matter of law, the military commissions are fine. They have been used throughout our history. As a matter of policy, they haven't worked. So if we use the military commissions, at least since we've had them established, since Guantanamo is a place we're holding the detainees and is a place where we think the system's already in place and acted in firm position, why not use it? And then last, what I recommend and what my forthcoming book details in greater analysis is really a hybrid court system, a national security court system, really the true mixture, if you will, of the military commissions and our federal Article III courts as the best way for now, for the remaining detainees, and for the future to best ensure that our national security is promoted while still embracing the rule of law and promoting human rights. And hopefully I'll get a chance later to go into more detail about that.
Yeah, and I really want to kind of defer for a while the whole question of prosecution. I want to stay on this issue of detention. I want to pick up on something you said, John. Let me suggest to you that the Uyghurs, the Chinese, who are determined to be insurgents by China, but the United States has acknowledged are not enemy combatants. We're not supposed to use that term anymore, but so that's a unique issue because we would normally send them back to China, but we can't. Our own immigration law prohibits us from sending someone back to a country where there's a reasonable belief that they would be subjected to torture. I am more worried about some of those at Guantanamo Bay who were declared to be enemy combatants, but for which there is no credible or usable evidence of criminality. And yet, many folks, the intelligence community says they are dangerous people. Now, if in fact Guantanamo Bay is not continued to be used, my question to all three of you is, yes, diplomatic efforts. We are hearing from at least the European community that they're saying, you're asking us to take those from Guantanamo Bay into our countries, but where's the United States offer here? Question, should the United States take terrorists, alleged terrorists, into a domestic preventive detention program in the United States, one, as a matter of policy, and two, is there existing legal predicate to do that? John, I'm going to go back to you starting on this. Is there the potential to bring those that will never see a criminal trial into the United States for some kind of a preventive detention program?
Yeah, I mean, I'll start with the law answer and then go to the policy answer. I think there's the only basis under the current law to detain preventively is very limited. It's the 2004 decision of the Supreme Court in Hamdi versus Rumsfeld, where it interpreted the the statute that the government, the United States has relied on for its detention operations at Guantanamo and elsewhere, the 2001 authorization for use of military force, which is a admittedly broadly worded statute, but does not specifically mention or deal with or address the question of detention. And what the court has said is the statute needs to be construed narrowly and consistent with both the Constitution and the laws of war. And under that statute, the limited group of individuals who can be detained are, as enemy combatants, or whether you use that term or not, in military detention without trial, are soldiers who fought against the U.S. troops, U.S. or allied forces on a battlefield in Afghanistan. But it cannot be used, in my view, more broadly to detain individuals who are not traditional combatants, but who are suspected criminals. Those individuals need to, under current law, be brought to trial if they're going to be detained. As a policy matter, I think it would be that we should not be detaining anyone anymore at Guantanamo without trial. I mean, I think it's kind of a false, the idea of detention and trial kind of breaks down at a place like Guantanamo, where individuals have been held for more than 8 years, or almost 8 years, and where the prospect of detention is truly indefinite and potentially endless. I mean, there's really, the idea that this is some sort of, pre-trial or detention where you're going to get a trial is a myth for most of the detainees there. And I think that given the circumstances at Guantanamo, we should not be detaining anyone preventively anymore as a policy matter. And that if we're going to, the small group of individuals who are truly dangerous at Guantanamo should be brought to trial in federal court. And I've not seen that there's been, a convincing case made that individuals cannot be prosecuted under current law.
All right, so I think I hear you saying, John, that you either bring them to a criminal trial or else they should be released. If there's no usable evidence that can be available to bring them to a criminal trial of some sort, which we'll talk about in a minute, they should just be released.
Right.
John, I think you're suggesting that a viable option is still Guantanamo Bay as far as detention. Is there any circumstance under which you think that detainees who will not be facing a criminal trial should be brought into the United States for a preventive detention program?
Well, first of all, excuse me, we could try to develop a program like that. I mean, that would be a debate that different organizations and individuals would have as to whether we should change our laws to reflect the laws of some other Western nations that do have preventive detention. My own position is sort of back to fundamentals, back to blocking and tackling. This will, bend some people out of shape. We're at war. If we're at war, we have the authority to detain until the war is over. Lots of debates to be had. Well, this is really different because they're non-state actors. How long will the war last? How are you going to know when the war is over? No, I understand all of that. But the fact is, we are at war. Every branch of the United States government has said we're at war, and at least 3 other international organizations have said we're at war. And when you're at war, you detain people. Why we link detention to trial is beyond me. We can detain these people, period. Not the Uyghurs, of course, but we can detain people because we're at war. Why did the administration bother to start up commissions? There was no requirement to start up commissions. I've not been able to find anybody from 8 years ago who can answer that question as to why they bothered to create the PMO and to move forward with commissions. There may have been some policy reasons for doing that. They thought it would be a good way to demonstrate to the American public how bad these people are. It was certainly ill-conceived. In 1944, there were 420,000 detainees in the United States from the German and Italian armies. Granted, they had PW status, but they were detainees. And it made no difference whether they were cooks or clerks or Jeep drivers. It made no difference if they wanted to be in the Army or not. It made no difference if they picked up an arm or not. Some of them may have never fired a weapon. They were conscripted by Mussolini and Hitler. But the law of war was clear. You detain those people until the war is over. And in the Vietnam War, hundreds of our people were detained by North Vietnamese, and the United States government's position was very clear through that entire war. You got them, you keep them, we get them back when the war is over, whenever that is. I was an enlisted soldier in the Mekong Delta in 1969. I guarantee you, I didn't think the war would be over in 1973. And we had no idea how long the war would be over. And yet our government's position was consistent. We didn't ask for them to be released. We didn't ask for them to get trials. We didn't demand that they have lawyers. We understood the law of war. The law of war is, if you capture people on a battlefield, you detain them until the war is over, however that's defined. And wars always look like they might last forever at any given time. So that's where I come down on the detention.
Let me ask you a clarifying question, John. Clearly, even Geneva Convention supports detaining an individual until cessation of hostilities. That's international law. The question that's often asked, and I want to pose to you, is when you're dealing with a, quote, conflict against terrorism, which is really a tactic rather than people, when is the cessation of hostilities? Is it when the last terrorist group anywhere in the world that can do you harm is defeated? And further, how do you define the battlefield? The Bush administration, I think, I fairly said, has defined the battlefield as anywhere in the world where we can be attacked, and theoretically right here in Durham, North Carolina. So how do you apply the law of war that you're talking about to a circumstance that is decidedly different than Vietnam in your experience?
Okay, well, I don't pretend to have answers to all those questions, but I think those are the debates that we should be having in academia and between governments and with individuals that give a darn about this, rather than a debate about how long do we hold them before they get a trial, and when do they get a trial, and when do they get a lawyer. Those are the wrong issues to debate. These other issues are very difficult. It's a watershed time in the history of humankind. That is the power of non-state actors. And so we got to find some way to come to grips with that. There's 192 nations in the world. If you were to rank the capability of the 192 nations to conduct offensive operations against other countries in the world, I would think that Al-Qaeda would rank in the top 30. And they're not a nation. But they are a nation in many ways. And if you were to rank even their economy or their GDP and the resources they have to make these things happen, they're not 193. They're way up in the middle in economic power of countries in the world, and yet they're not a country. So they play by different rules, which is to say they play by no rules at all. So I think those are the kinds of issues that we should come to grips with and recognize that they're very difficult. It's not easy, but there's certainly a good argument to be made that the battlefield goes beyond Afghanistan. And the last thing I'll say right now is about what you asked me is that it's clearly not a war against terrorism. And it wasn't a war against terrorism in the previous administration. It was at best, inartful characterization of a war that we're in against Al-Qaeda and other organizations like them. And that's who the war is against. And that ought to be the starting point in trying to define terms of, well, how do we tell when the war is over, and how will we know is who's the war against? And it's completely confused by the concept of a war against terrorism. That was very counterproductive.
Glenn, let me bring you in. Again, I want to stay with the tension here. If we're going to move folks out of Guantanamo Bay, if the president decides for whatever reason he's going to stay with his timetable, bring him into the United States?
I think if we do that, yes, we should. But I think any sort of regime we should be resistant towards preventative detention indefinitely. Presumptively, any sort of a move to the states would be for adjudication, not necessarily for the
Is there existing legal predicate to do that?
To have presumptive adjudication? Sure. I mean, to have
preventive detention for indefinite?
Oh, I think definitively for us to bring them here to have preventive detention. Ben Wittes's book, The Long War, goes into great detail about a variety of other areas in the law that we do that for, even for mentally incapacitated people. He goes through a list of different items of folks that we use preventative detention regimes for. I don't think they're applicable, Scott, in this case at all. I think with all due respect to my good friend, I think it's faulty in terms of his reasoning to say that's somehow analogous to using preventive detention regimes for the Al-Qaeda fighter, the captured Al-Qaeda fighter. But the key, I think, if I could, is that, as you alluded to and the general alluded to, it can't be viewed in a vacuum. I think we can't just say, are we for or are we not for? It's much more complex, and as the general was alluding to, two items really need to take place. And I've advocated for this for a while, to change the name of the war. I mean, I think that is true. I think calling it the war against terror created all sorts of ambiguities legally, strategically, and tactically. And there was a way we could provide some means to at least focus for what perhaps is most important to us, the legal issues. And that would help us to be able to look at any sort of detention. If they're truly captured Al-Qaeda fighters during a period of armed conflict, then we could classify them as POWs then. We could know a cessation of hostilities. I think the general would agree, and others might. I think we could win. We can defeat or disrupt Al-Qaeda, a known entity, to such a point where it's irrelevant on the world stage. Terrorism, as the panel was discussing before, we clearly can't. So there is no end. The other second item, besides changing the name, is a lot of the time it's such emphasis in the last few years on President Bush and mistakes he's made in executive power. I think we have to look, since 2006, a new party controls the Congress, and the AUMF is quite broad and quite sweeping, and a lot of the authority, even now that President Obama is assuming to perhaps engage in this sort of preventative detention, is granted to him by the Congress. Why isn't the Congress altering the AUMF to limit the scope, define where the battlefield is, tell him where it is? They can do that. They just haven't chosen or had the political courage or will to do so.
Well, all right, picking up on that, you and others have talked of a national security court. Now, there are two variants of that. One would be a criminal court, and we'll talk about that. But Jack Goldsmith, Anil Kachow, who is now the Deputy Solicitor General, suggested that Congress, under its constitutional authority to constitute tribunals inferior to the Supreme Court, could establish an Article I court that would control detention, that would somehow build in some kind of review to allow for domestic detention. Is that a good idea?
I don't think so.
Why?
I think what we're doing by creating a preventative detention scheme without, if we're doing it in a vacuum without the other items of legislation and changing the name of the board and other items, what we're doing is bringing Guantanamo and the associated policy problems with holding people for 7 years just into the United States. All we would do is be transferring a problem at an isolated place off the coast of Florida into the continental United States without having any sort of end game. And I don't think the international community nor the national community, who have reservations about, rightly or wrongly, whether Guantanamo is being successful, would accept this sort of a regime. I think it's politically untenable in many ways.
John, I think you've indicated earlier, under no circumstances would you have any kind of a preventive detention system. You want to try them or release them. Is there any situation that you would accept if Congress created a court that would periodically review, have some modicum of due process involved for detention only, not trial? Is that anything that you or ACLU would ever find acceptable?
I mean, outside of we do accept the preventive detention of combatants who fight against U.S. forces on a battlefield, with an enemy, certainly with an enemy state. I mean, the traditional combatant. So just to be clear, we're not saying that everybody the military captures under all circumstances has to be tried. But as to a preventive detention regime of the type that we're really discussing here, we certainly would oppose that. But let me be clear. I also think that as from a legal matter that at this point there is no. And it's where we may disagree here with some of the other members of the panel. There is no authority under statute right now to preventatively detain individuals, at least outside of the sort of narrow Hamdi category, the battlefield combatant that I mentioned earlier. The AUMF does not provide that authority. The traditional laws of war don't provide that authority. In fact, the laws of war say basically exactly the opposite, which is that when you're detained, if you're going to detain in a non-state actor, the laws of war themselves don't provide independent authority to detain. That has to come from, there has to be some kind of of positive domestic law, some kind of, if you will, preventive detention law. And we don't have that yet. So we've been operating without any kind of statutory authority to detain individuals for, at Guantanamo, again, at least outside the Hamdi combatant areas. I don't think it would be a good idea to adopt that. I think it would be, it would certainly oppose it as unconstitutional. But at this point, I don't think there's authority to do it.
All right, let me ask you a policy question. Let's assume that Congress passes a statute that authorizes some kind of a domestic preventive detention system. Is it a good idea from a policy point of view? We've not done this. John's very correct that we detained, we interned Japanese Americans, we interned Germans, but that was done under the law of war in World War II. Does this become a slippery slope? If we start a domestic preventive detention program with at least the possibility of indefinite detention with all sorts of judicial filters through some kind of a specialized court, is this something that the United States should commence? John?
No, I mean, I think it's not. I think it's against our traditions, and I think you have to look at the reasons why such a scheme would be enacted. And in fact, the reason that we preventatively detained many of the individuals at Guantanamo. I mean, you're trading away the presumption of innocence. You're trading away, core procedural rights that are synonymous with due process, the right to confront your accusers. You're also you're trading away the idea of a full and fair trial if someone's imprisoned. And I think also it's important to not look at the detention issue in a vacuum, but as you mentioned at the outset, Scott, today we saw the release of a number of the OLC memos dealing with torture, and I think that this is the whole approach and the, if you will, the effort to legalize torture and other abusive treatment was really tied up with the idea of trying to create an alternative detention framework, whether it's detention of enemy combatants or trial by military commissions. The reason, a driving force behind Guantanamo and behind the effort to create these alternative categories of enemy combatants and preventive detention was an effort to engage in coercive interrogations and to insulate coercive interrogation tactics from review. And I think a concern that going forward that I would have with a preventive detention system, another concern is that it would be an effort to continue to shield coerced testimony from review and to open the door to its continued use in the future.
John, I know you'd like to keep Guantanamo Bay open, but from a policy point of view, detention in the United States, good thing, bad thing?
I think it's a bad thing. As I said, there's not a good alternative, and we're being chased by a reputation. We're being chased by an erroneous impression that the American public and the international community has about Guantanamo, what it is. So, I mean, I'd toss a coin as to where you put them, quite frankly. I mean, people in Colorado aren't too excited about putting a bunch of those guys out there in the Supermax, nor are the people in Marion, Illinois, and I know that the senators from Kansas are already on record.
I think John Murtha said, not in my district.
So, I think we're chasing our tail, personally.
All right, let me move to a related
Scott, if I
question.
could on that,
Yeah, sure.
just quickly, I really, I think this goes to a little bit when we're listening. It's interesting. We really have to find a balance, and we're still struggling since 2001, and many of the folks in the room have been struggling with whether we're engaged in a law enforcement action or a war. And I think interestingly, Scott has it set up. Clearly, the general believes we're engaged in a war. I would suggest Jonathan does not. This is really a law enforcement action for the most part, excluding the operations in Afghanistan. That when we're looking at this fight against international terrorism or this war against Al-Qaeda, that when we bring someone, if we do set up, if Congress sets this up legislatively to have some sort of a preventive detention scheme within the United States, if that is embraced, or at least looked at, that it shouldn't be one that we would say indefinitely. Perhaps there is a middle ground to looking at this, that perhaps within a year, you give a chance to balance the needs of the military community and the intelligence community to conduct interrogations, to clearly, one of the things here is we have to remember we're talking about promoting our national security. We can't get so engrossed into the fact of trying to provide rights, which I do, and we all do, and provide process, that we lose sight of what we're trying to protect against. It has to be appropriately balanced. And perhaps if we have that sort of a regime set up where it's not indefinite, but perhaps within a year, there's a trial begun, not still preventative detention, not trial, but that we have that sort of a regime set up, and perhaps a sunset provision. That worked well, the USA Patriot Act, that perhaps we do this for years. It doesn't have to. One of the items that I hear frequently about any sort of a national security court for detention or adjudication is, gosh, Glenn, we're going to have this 50 years from now. Where will it be? Well, perhaps have sunset provisions, 5 years, have Congress relook at it.
One question before we deal with prosecution friendly. I mentioned in my comments opening our panel, Judge Bates earlier this month, I think on the 2nd of April, basically using Justice Kennedy's functional logic from the Boumediene case, found that 3 of the 4 non-Afghani detainees at Bagram Air Base who had been captured outside of Afghanistan have constitutional habeas protection. Now, without trying to predict what the courts above will deal with that, my question is, from the military point of view, as John's kind of alluded to, you capture people on the battlefield. But this ruling suggests that if you capture someone on the battlefield in Iraq, but because you don't have a suitable detention facility in Iraq, and you move them to Bagram Air Base in Afghanistan, that under this ruling, potentially, they could be extended constitutional habeas protection and the courts would have jurisdiction. John, let me ask you first. Would that be the view that you would take if you move a detainee from the place of capture, which is one battlefield, to another country, which is yet another battlefield? Should the courts have jurisdiction and offer habeas relief?
Let me try to answer it this way. I think the decision involved, it wasn't that the people who the petitioners, all 4 petitioners, in fact, although there was a dispute about one of the 4, but certainly 3 of them were moved to Bagram from elsewhere, although they were picked up in places like Thailand. They weren't really picked up on the battlefield. They were picked up as part of a kind of, however you want to characterize it, it was a global, I view it as more of a law enforcement action, but they were picked up and brought to Bagram. They were, in fact, these were like, in some sense, a number of the people that years ago would have been picked up and brought to Guantanamo. You can take, for example, Lakhdar Boumediene, the petitioner in the 2008 Boumediene decision, who was picked up in Bosnia and brought to Guantanamo. It was effectively what was rendered there. And so I think what the judge in the Bagram case was responding to, in part, was the idea that Bagram was becoming or serving the purpose that Guantanamo had in the future. Individuals were being picked up from outside of Afghanistan and brought to Afghanistan, where the right to habeas corpus had not been established yet. Clearly, it was established at Guantanamo and had been first established in 2004. And so I think certainly that those individuals have constitutional protections under the test set forth by the Supreme Court in the Boumediene decision. And one of the most striking points of Judge Bates' opinion in the Bagram case, and this applies not just to those petitioners who were brought in from elsewhere, but to the majority of prisoners who were picked up within Afghanistan, is that the process that they've received to challenge their detention through the military, and all of them have been held for more than 6 years, was less adequate than the process that the Supreme Court had struck down as unconstitutional in the Boumediene decision. Where those prisoners are being held shouldn't matter. The fact that they're at Guantanamo, shouldn't mean that if you're at Guantanamo, you get the fair process that's now provided through the habeas. But if you stay in Bagram because you're not transferred to Guantanamo, you're picked up there, you get a process that's been deemed insufficient, unconstitutional, and inadequate. And I think that's a real problem that Judge Bates put his finger on. I don't agree with his solution, but I think that's an important point.
Let me shift now to the other focus of our panel this morning. Again, the release of the memos which you sued to get, John, you and the ACLU, indicate that some of the interrogation methods used under the authority of legal guidance issued by the Department of Justice Office of Legal Counsel, Steve Bradbury signed many of those, created a regime whereby statements were taken that perhaps under the Convention Against Torture or some other convention would be deemed by everyone else to be torture, and therefore any statement could never be used in evidence. If we're dealing with those folks who have clearly violated the law of war, those like Khalid Sheikh Mohammed, Ramzi Ben al-Shib, al-Zanira, who allegedly were complicit in the attacks of 9/11, where is the best place to prosecute them? And let me suggest that there are perhaps 5 options. One, in theory, the United States could request the United Nations Security Council to create an ad hoc criminal tribunal, not the International Criminal Tribunal, because its jurisdiction only extends from June of 2002 on, but to create a tribunal as it has for Rwanda, former Yugoslavia, et cetera. That's one option. Second would be, John talked about military commissions, and John was the convening authority for military commissions. To reconstitute military commissions or leave them as they are and use them. A third option would be the Article III courts, the federal criminal courts. Jose Padilla was prosecuted. Your client, Omari, not prejudging his guilt, John, but he will be prosecuted in the federal courts. Yet another option, I think, would be the use of military courts-martial, which I would suggest the United States Supreme Court, in the Hamdan decision, declared to be the gold standard under international law. And then going back to something Glenn mentioned, is a criminal national security court that Congress would create. So theoretically, 5 potential options. Maybe there are more. But which way should we go? Glenn, let me start with you.
First, if I could go back to Boumediene for a second or not, is that right?
Okay.
All right, I'll go right into this. Just amazingly, that's a case I know most of you have read and reread. I really think it was a terrible, terrible opinion. And I think what it did was shift us back from a pre-9/11 mentality from the court's perspective. When we're talking about discussing whether it's a war or a law, I think it was the first time I really sensed, we know it's the first time the court found a constitutional defect in the military commissions. But it also now went ahead and clearly began the process of moving this towards being a law enforcement action and no longer a war, and granting a constitutional right, abandoning the military deference doctrine, abandoning centuries of precedent in that regard, not listening to the military's perspectives on why they would hold somebody. I mean, also, back then when it came out, I was concerned, and I think rightfully, that we would start having litigators from various interest groups saying if he has one constitutional right, then why not others? Why not the 4th, 5th, First Amendments? And sure enough, our good friend Neil, even the military commissions process, had a laundry list in the military commissions process as a result of Boumediene went for Hamdan listing a bunch of rights that should be granted. They were denied, but it still is in any sort of good litigator's mind to do so. I think the other item is that we expect, if it's okay for Guantanamo, and the ever-wandering Justice Kennedy did limit it to Guantanamo, supposedly, but certainly Bagram is another area, certainly that's going to be analogized as Judge Bates has done in a limited circumstance, but that's going to continue to expand. And just last, before I answer the question that Scott wants me to answer, is the when we talk about POWs and detainees, Boumediene gave more rights to the folks that violate the laws of war, gave them a constitutional right that in a traditional armed conflict a POW wouldn't have. Bottom line. They have more rights right now than a POW would in traditional armed conflict. So I just leave it why I'm uncomfortable with it. The right way, because of that, the right way or court to look at this, I clearly think the right system to prosecute these folks is through a national security court system. If we look at this, because of what we're discussing, is a hybrid war of some sort, a mixture of law enforcement and warfare, 4th generation war, with hybrid warriors, mixture of international criminal and warrior, that the right place to have something like this is a hybrid court or a national security court system, a mixture of both the military commissions and our federal Article III system, with civilian oversight still, but recognizing it's still an armed conflict. We're running the risk right now of diminishing the realities of this being an armed conflict by pursuing potentially litigation in our traditional Article III federal courts.
How much due process? You're going to let hearsay in? You're going to allow for statements taken under some measure of coercion? Is that what you want?
Yes, it would be
So what's the difference between that and a military commission?
civilian oversight. One of the items that we're talking about, I think, perceptions matter to our international friends that are here. Perceptions matter, as we heard last night. Appearances matter. We have, rightly or wrongly, military officers sitting in front with an otherwise civilian, sitting in front being tried before a military court. Those are the types of activities that we are normally, as Americans, uncomfortable with. Having civilians standing before a military court with the trappings of rank. We normally, the State Department issues guidelines and reports on those sorts of things as being potentially human rights abuses by folks. We know that's not true. We know the armed services, I believe, and I think most in the room, are noble, wonderful warriors committed to promoting the rule of law and doing the right thing virtually all of the time. But we have to recognize the appearance being sent and having a civilian oversight of this process. But someone, and again, not to get into the specifics too far right now, but a national security court system would have a Article III judge, but a national security court judge, someone who's learned in the law of armed conflict, someone who knows international law. Like we have specialized judges for immigration, bankruptcy, why don't we have someone, and there are certainly a learned pool out there, the president can appoint for this tremendously important decisions that would be being made by this judge or judges in a national security court system. Wouldn't we want to make sure that they're experts in this area? We feel that strongly to have separate systems in bankruptcy, immigration, family law. Why not a national security court judge?
John? Which way?
Moi?
What?
I think there's a lot of merit in Glenn's proposal, in the hybrid court, and comparing the types of judges that would be appointed. Personally, I'd just have the Supreme Court Chief Justice appoint them, the same way he appoints other specialized judges. I think it ought to be left there, and there shouldn't be any guidelines. If there's a statute, the Congress should stay the heck out of what the qualifications ought to be and just let the Supreme Court Chief Justice pick them, period. Having said that, I think commissions work best. I think commissions are most efficient. And when we review the last several years of commissions and the desultory meandering that we went through, I think it's important to remember that executive overreach in 2001 and 2002 produced a pretty sorry executive order in the presidential military order. And so we had a bad start point. Executive overreach in the sense of why not consult with Congress? Personally, I think decisions that have said that there wasn't enough congressional authority are wrong. And for those, real familiar with the UCMJ, Article 21 is all the authority that the executive needed to do military commissions. Well, what would have been wrong with reaching out to the Congress and talking to them and coordinating that is beyond me. I think that that was a problem for the administration, that they wanted to do everything themselves. And in fact, probably use it as a platform for expanding executive authority in all kinds of areas. So there was a separate agenda there apart from national security, in my personal opinion. A part of that was their inflexible adherence to the language in Kieran, which was dated. We've talked before about the incredible irony of lawyers relying, as we do, on the language in a Supreme Court decision and the language in a presidential order 50 years later, but language that was based on a 1920 statute that had been overturned in 1948 by what few people know about, the 1948 Articles of War for the Army and the Air Force, and the subsequent UCMJ in 1950. Not to even address the most significant change in military justice in our history, the 1968 amendments, and 50 years of judicial process and cases that completely changed the nature of military justice and military law. And without any reference to any of that, we dive back to 1942 and an order based on a 22-year-old statute. It's beyond comprehension, really, that there wasn't more input from others to fashion a different kind of presidential military order. The last point I'd make about that, as we review commissions, because I know that probably one of my colleagues up here's arguments for doing something other than commissions is that they're supposed to be fast, they're supposed to be efficient. Here we are 8 years later. I would submit to you that they didn't do anything between the publication of the Presidential Military Order and about 2004 as a practical matter.
Which is when you took over as convening authority, right?
That's right. That's when they appointed somebody. They appointed somebody other than a deputy secretary. They all at once, for some reason, they wanted to get this thing going, but that's 2.5 years later. Nothing really happened for 2.5 years. Oh, people were filling jobs and looking at cases, but nothing, there was no urgency at all. So also remember, go back to that initial question, why are we bothering to do commissions when we've got the authority to detain anyway? You knock out all the intelligence issues if you don't bother to do commissions, you know. The only commissions we did during war that I can remember were Kieran and maybe one or two others. By far the majority, the over 90% of the commissions that were done because of World War II were done after World War II, when you lift the curtain on a lot of the intelligence matters. But at any rate, from 2004 to 2006, well into 2006, we're engaged in Supreme Court litigation. That's good, that's our process, that's our system. But basically, military commissions as a practical matter started in 2007, and we haven't gone 2 years yet. And we've had 20 cases down there, referred to trial, hearings, court date set. So if you look at it from that perspective, it is pretty efficient, and it is moving along, because it really didn't get cranked up until 2007.
John, I'm being presumptuous. I gather you would say Article III federal district courts.
Yes, I'm not going to surprise you, Scott. I mean, I think, but let me start by saying, I mean, you know, we'll talk about, and from, you know, a detainee or from a criminal defense litigator's perspective or a civil rights perspective, they are protective of defendants' rights, you know, but I think it would really be a mistake not to see how effective the criminal courts are at detaining people before they commit acts and at locking them up for very long periods of time for plotting or carrying out terrorist activities. The criminal justice system is also, and the law enforcement approach is also very effective and has been far more effective than the other approaches that were employed at gaining intelligence. You take a look at Abu Zubaydah. The useful intelligence that was gained from Abu Zubaydah was gained by the FBI, applying a law enforcement approach, and not by the CIA, who had who used the reverse engineered the SEER techniques, which were used to train U.S., as many of you probably know, train U.S. military to withstand torture, were re-engineered and used against Zubaydah and others. This produced much false intelligence. One government spokesman was quoted in the Washington, or government official was quoted in the Washington Post saying millions of dollars, tons of time was lost. So the criminal justice system is very effective. I mean, and you can look at the military commissions by contrast. The first person who was tried and convicted, David Hicks, who it's both fair and it's daunting. I mean, he is now looking at a potential 30-year sentence for 2 counts of material support to terrorism. He is vigorously challenging the allegations, but the sentences that can be imposed by the criminal justice system are the most severe imaginable, and they carry with it the legitimacy. There may be quibbles about the way aspects about the way trials were conducted or different issues, but no one questions that the system itself and the rules that are employed are valid, legitimate, and basically and consistent with the Constitution. And I think it's dangerous whether it's to try to kind of revive the military commission system or to start a new national security court system of trying to, the same problem of trying to create something new and trying to reinvent the rules when we already have these rules in the criminal justice system. We have an extensive code of of statutes that substantively, and a developed body of rules procedurally, including rules dealing with classified information, and judges and institutional players, prosecutors and defense, that sort of are able to handle, pretty well all of the new challenges that arise through terrorism cases.
Let me posit an alternative that none of you have yet mentioned. John, you talked about the UCMJ, 1968, substantial improvement in due process. 1984, United States Supreme Court, I think, gentlemen, in the Hamdan case, when it applied Common Article 3 of the Geneva Convention as against military commissions, found them lacking, but cited the court-martial system as meeting, I think it even called it the gold standard. Am I correct? All right, so what's wrong with this? With a two-word change to the statute, including into the jurisdictional Article 2, unlawful combatants rather than lawful. What's wrong with taking the Uniform Code of Military Justice, which we use for our own servicemen and servicewomen, which I believe the litigators, John, initially said to those at Guantanamo Bay, don't use military commissions, either try them in the Article 3 courts or a court-martial, I think. A court-martial can be convened and held anywhere in the world, not necessarily the United States, so you don't have a security issue, and a convening authority under the Uniform Code of Military Justice can designate a confinement facility anywhere in the world. Why not courts-martial? Why?
I think all of these processes work. I'm not opposed to any of them. I think that Glenn's notion of a hybrid court can work. I think that Article 3 courts work well, as Jonathan says. They've been proven to work well. The New York District Court in the Clinton administration convicted 25 out of 25 terrorism cases. So they can make that happen. They can convict a lot of these cases. And a courts-martial will work, but not in all cases. And that's the problem, and that's where commissions come in. And maybe we need to use all of these processes. It's important, first of all, to understand that courts-martials and Article 3 courts are almost exactly alike. And as a practical matter, in these trials, in trials against people picked up on the battlefield for war crimes, they would be identical. There would be no difference. People got to get that in their head. There is no difference. Court-martial doesn't give you any advantage over an Article 3 court other than the universal jurisdiction
and being held outside the United States.
And held outside. Well, that's the universal jurisdiction piece. Right. You can do them anywhere. The UCMJ goes with us wherever we go. By the way, commissions are UCMJ. And it's important that people start misusing language and they start talking about UCMJ as opposed to military commissions. Commissions and courts-martials are two of the 4 tribunals mentioned in the UCMJ. So when you say UCMJ, you're including commissions as a practical matter. There's 7 articles specifically referring to commissions in the UCMJ. And I lost my thought. What I wanted to say was, so let's talk about Article 3 courts and courts-martials in the same breath. Why not? Well, you can for some, but where the case is going to depend on the admissions of the accused person, on statements that they made that can be corroborated, okay? And let's just take off the table coercion. It's a statement that hasn't been coerced, okay? It's not going to come in a court-martial, and it's not going to come in an Article 3 court because there were no Miranda warnings. End of discussion. It ain't going to happen. And that's why you need a military commission. There were no Miranda warnings.
John, why not courts-martial is against what you're advocating, Article 3 courts?
I certainly think courts-martial are the next best alternative. And I think there's just again, it's sort of a fundamental question. I think that the acts that the individual, many of the individuals who were brought to trial before court-martial are criminal violations. They're not subject to the laws of war. So that's one issue. But I think in terms of procedural fairness, court-martials are generally, tantamount or equal to federal criminal trials in some sense. In some sense, in some senses they're better. But so I think it's the objection would not be then to the procedural fairness of court-martials, which is I think, and I think it's actually telling that in electing to sort of adopt a war paradigm, if you will, to fight terrorism, the prior administration and I suppose still the current administration did not opt for the court-martial trials with their panoply of protections. I think it's very telling. And again, I mean, I go back to the reason that the commissions were created in large part, in my view, was to be able to shield evidence that would be inadmissible from a federal criminal trial or a court-martial, and not because of Miranda warnings, which certainly in the federal criminal context there are many exceptions that allow evidence in, public safety exception being one of them. But again, to kind of sanction, and to protect torture and coerced testimony.
Glenn?
Just to answer that before I talk about the court-martial, I think when we say that I'm a little bit, it's a little disingenuous to say that the Bush administration purposely set up a preventative detention scheme. I would suggest that over time it happened for whatever reason, whether by accident or through successful litigation by those that were protesting. I don't think the intention was to set up a preventative detention regime. I remember vividly Colonel Bork was about to begin the first military commissions in July of 2003, and it was put out in the media. New York Times quoted in April, May, the military commission's about to begin. For whatever reason, they did not, but I don't think it was an intention. It became one de facto, but it wasn't intended to be. So I just think, and I think looking at Quirin, and I understand the general's angst and others' angst about it, I think you have to put yourself in the time frame. We're talking about a lot of these decisions that the administration was making. We really do. I mean, all of us in this room were sitting expecting additional attacks. Intelligence reports were saying that. Yes, it may have been rushed, and I would agree with the general that it was not the best possible analysis or order, and certainly consulting with Congress would have been prudent, since we did for the AUMF and other items, the Patriot Act and others. But I do think that when we're looking at how they constructed this to begin with, if you're sitting there a month afterwards, President Roosevelt issued his proclamation, if you're looking at historical analysis for the military commissions, days after the German saboteurs were caught. He also told specifically President Roosevelt to his Attorney General and to his TJAG, I don't want to have any habeas proceedings for these guys. I don't want any sheriffs coming to free these guys at all. Specifically gave an order. So during time of armed conflict, all folks make these sorts of perhaps mistakes or perhaps unintended consequences result from operating in a period of incredible stress. So I just put that out as a defense for those guys that were making some of those decisions during that time. I actually applaud their efforts in many regards, knowing that some of them were wrong, but I do know that under the circumstances it was quite difficult. In terms of the, I think the concern with the courts-martial, Scott, predominantly go back to perceptions. One is that military oversight, again, I think having the court-martial system, no matter what, it goes back to my concerns about having military oversight rather than civilian oversight of this unique hybrid armed conflict. And the other one, which has come up throughout, and a couple of the prosecutors additionally, and Colonel Morris has said this, is the unlawful command influence, appearance of unlawful command influence on either actual or appearance of the convening authority or others manipulating or encouraging certain actions, which is tough to get rid of. Now, we don't know if that's true or not for General Hartman or other folks that have been involved, but that is something, we remove that taint altogether if we don't use the military courts-martial. General?
What I want to do now is I have tried to ensure that in every panel and every speaker we had more than enough time for your comments and questions. So at this time, I am going to invite Matt and Bev, who have the microphones, to start to circulate. And I see John Bellinger already has his hand. Bev, if you would get it to John Bellinger, who I'm sure has a point of view on this. He's right here. Bev, right next to Lynn Hogue. Right down. Oh, John, Bev's got one right for you. Question from John Bellin.
All right, well, I can't resist, since this is the first time in 8 years in which, rather than be on the panel getting to answer questions, I get to ask questions of others. No, it's a very good panel, and thank you. And not surprisingly, my question is going to be for Jonathan. On federal trials, I mean, as you well know, I have had for 8 years many concerns about the military commissions, many of them shared with John Altenburg. Much of the problem was bad process. Bad process resulted in bad substance. It was sort of stunning that the military commissions were set up without half of the U.S. government, the State Department, the CIA, the National Security Council being involved. My own view is that, frankly, because of the illegitimate birth of the military commissions, they've been viewed essentially as sort of a bastard child for the last 8 years. And no matter how they get fixed up, and no matter how hard John and I tried to fix them up, that people have discredited them. But just because of that problem doesn't necessarily mean that you go to the other end and say, well, federal courts are the only way to go. And I got a couple of questions for you. I mean, what's essentially being circulated now by human rights groups and civil liberties groups, that federal trials are the only way to go, with the evidence being that in the last 8 years we've had 100 federal terrorism trials and they've worked, and ergo it proves that the system works. I guess my response to that is every single one of those, or at least almost every single one of those, involve people who were arrested inside the United States by the FBI. And what we're talking about here are people who were either directly detained or turned over to our military in a foreign country, often in the midst of combat. And I agree, you can quibble around the edges about people who were detained in Bosnia and taken to Bagram or given over to the Pakistanis. But the fact is, these are not the paradigmatic case of people arrested inside the United States by the FBI. These are people being detained by the military outside the United States. So I don't see that there is any proof at all that because we can have a federal trial of people inside the United States, it proves that it fits those cases. Second, you have to have some sort of a system that fits all of the cases in some way. And we're not just talking about Guantanamo detainees. We're talking about people who may be detained by our armed forces today or tomorrow. And it seems to me that if the signal that we are sending, or the rule that we are setting down, which is to say anybody detained by the armed forces in the future may not be detained unless they can be brought before a federal court, what sort of a signal is that to our military, to a soldier in Afghanistan, that if you can shoot someone and kill them, that's fine, but if you detain them, then you can only detain them for X number of days before they've got to be brought back to the United States and tried before a federal court. And again, maybe some of them could be tried in Afghanistan, but suppose they've actually set an IED beside the side of the road, killed some Americans, and that we'd like to try them. Why is it that a federal court to try a person like that is the best way to go? So again, I think these are difficult cases. This is not a full-up defense of the military commissions. I have to just say I think it is somewhat misleading to suggest that the federal courts have always worked, and therefore that they will always work in the future. I agree with John's point, maybe not everything he said, but with the point that we're in new legal territory, and that we shouldn't just say, well, what we've always done in the past is what we should do in the future.
All right, John, you want to answer that softball question?
Thanks. Okay. Thanks for the question. I think, first let me start out. When this all began, I don't think that there was the decision to create military commissions, and was part of a thoughtful process about what are the problems with the federal courts. I think in my view, may have a different view from being on the other side, at least after, it was done as a part of a larger series of decisions to create not to adhere to the Geneva Conventions, the series of interrogation memos, but basically to kind of create a category of prisoner outside outside the law, right? I mean, the idea of an enemy combatant that had no legal protections under the Constitution or international law. And I think the commissions were part of that system, and I understand and I agree that they have come away since then and are provide, you know, in the second go-round after Hamdan, more process than they provided before. But I don't think they were ever initially done as part of the idea of military commissions, as part of a thoughtful decision about the problems of the federal courts. I agree and this is true of the human rights first report that Glenn mentioned. Most of the trials and cases discussed in that report involved domestic arrests, you know, for example, like Padilla or like Almari. But there are examples of successful federal trials where individuals are captured, seized overseas. The Second Circuit just upheld the conviction of individuals for the bombing of the embassies in East Africa. Those involved extraterritorial arrests. And actually one of the on the other side of the coin, what I think is would be, you know, it's concerning if you're focused on, you know, the problems of extraterritorial seizures, is the way that I think, you know, from some who are proposing alternatives to the criminal justice system, that Guantanamo is kind of being used to kind of bring in a preventive detention system that doesn't distinguish, and that would allow the idea to preventively detain people arrested in the United States, where some of the concerns or problems you raise just don't exist. And it's being used as kind of a Trojan horse to Guantanamo to create a domestic preventive detention system focused on picking up people in the United States. In terms of going forward, the last part of your question, I don't take the position that individuals picked up in Afghanistan in the theater of conflict, you know, necessarily have to be given federal criminal trials under the Supreme Court's decision in Hamdi, at least to the extent that they directly participate in hostilities in the theater of operations. They can be detained by the military. I think there's a policy question about whether we want to be holding individuals or we want to be having them, you know, using the Afghan justice system now that we're not at war with Afghanistan to prosecute them, which is, I think, more what England does. But in any event, that's not, my position or ACLU position. And then, you know, just finally, I think, you know, to me, the biggest problems have been, in terms of the detention, the idea of kind of expanding war, you know, beyond where it has ever kind of gone before, into using to conduct detention operations, seizing people, you know, picked up thousands of miles from a war zone or even in the United States, holding them as combatants on the one hand, and then on the other hand, not adhering to the laws of war and the military's own regulations, where the military is engaged in hostilities. There was, right after September 2001, when the U.S. military was in Afghanistan, the military wanted to employ Army Regulation 190-8 and the procedures that have been used. They were used in Vietnam. They were, I think, created in Vietnam to, because of the difficulty of telling friend from foe, to provide a prompt hearing, a fair hearing under the circumstances, and civilian officials in Washington overruled them. And it was akin to the fact that the JAGs were excluded from the process to create military commissions. So it's this idea that certainly in the early stages of the kind of post 9/11 era of trying to sort of expand war where it had never been before, and then not to follow the rules and regulations that the military has always kind of followed in war. And those are, to me, some of the biggest problems.
Yeah, in all fairness, though, John, when you talk about the Hamdi case, I think it's true, John, that when the Department of Defense created the Combatant Status Review Tribunal system for Guantanamo Bay, it was modeled on Sandra Day O'Connor's opinion, and Hamdi involved an American citizen. So the question is, if it's good enough for an American citizen, why wouldn't it be good enough for someone else? But let's take another question. In the back, yes. Is it Major?
Colonel, I think.
Good morning. I'm a lieutenant colonel at Special Operations Command. My name is Lori Kroll. I respectfully disagree with you that this is a law enforcement action. This is a war. I think historically we are used to dealing with state versus state actions, and that's not what we found that we're dealing with in this situation, which I think creates the lack of clarity. Given that the Geneva Conventions were drafted after World War II based on a conventional method of fighting and that we're no longer using that, do you think it's time that we revisit the Geneva Conventions? And if we're worried about perceptions, particularly throughout the world, wouldn't we want to engage our partners in possibly rewriting those Geneva Conventions to address some of the issues you've been talking about this morning?
Glenn?
Thanks, Colonel. I think, just to give you comfort, I know Georgetown University's Law Center is actually looking at this very issue right now and studying at the Security Law Project, as well as the World Justice Project, which I'm a part of a program looking at just that very issue. Whether there is an ambiguity, have we been trying to jam a square peg into a round hole? Is there a need for an additional protocol? Or is there, again, something beneficial to the United States bringing people together to look at them, just to examine them, to talk about them, to look at the different issues, to see where it does fit? Does Common Article 3 fit appropriately? Does AP1, even though we haven't ratified? Let's take a look at it. And I think I completely agree with you. I think it's something that should be looked at. And again, part of what we were talking about earlier about not viewing the military commissions in a vacuum is to look at the other items within a vacuum would be the AUMF, the name of the war, and also this. Where do the Geneva Conventions apply so that we remove some of the ambiguity that we're confronting and will continue to confront?
Okay, another question. I think it's Mike in the back, Mike Davidson.
Let me pose a question to each of the panelists, which is on this premise, that the validity of any of the models, military commission, court-martials, civilian trials, or a hybrid court, may be tested in relation to the answer to this, especially following yesterday's declassification of interrogation techniques. Is there any question now but that a defendant in any one of those proceedings who alleges that any statement was the result of a coerced technique, or who wishes to plead guilty, and the question to the court is whether the guilty plea is a free and voluntary guilty plea, whether there should not be now a public hearing on that question.
By public hearing, what do you mean?
In the
Mike?
proceeding. But
Legal, no, is they should be brought to some kind of a criminal proceeding?
Open proceedings.
Whether the
to
question is before any one of those forums, whether that forum should proceed through a public hearing of that question, rather than requiring that that question be dealt with in
Closed.
secret.
Okay. John?
I believe that any accused brought to trial in any of the fora that we've discussed up here who alleges that any evidence against him was a product of a coercive technique will receive a hearing, and that issue will be vetted and litigated extensively by both sides. Whether that should always be in public would depend on the circumstances and the intelligence resources and classification methods that protect national security. I would imagine, given the fact that the documents have been made public, which I think was a good idea because it certainly demystified and personally I think probably reduced the level of angst in a lot of people. I think some of the reactions are going to be, oh, it's be like the Peggy Lee song. Is that all there is? Because certainly people had implied that it was far worse than what the documents even reveal, in my opinion. So I'm just safeguarding. I'm not sure what might be out there that might still need to be protected for national security purposes. I personally have great confidence in any one of the systems that the four of us have discussed up here in terms of the judiciary in each of those, the prosecution and the defense functions, that there would be a full airing of the issue. I'm not as concerned personally, and I know that most people in the room probably don't share, I'm not as concerned personally with whether the media gets to see it and whether they get the report on it. I think there are some things that do have to stay out of the public's eye. for purposes of national security. But I think that would be, if there would be any issues, any instances like that, they would be very, very few.
Matt, you have a question?
Well, can you hear me?
Yes.
Yeah, go ahead. I think you're on now.
Hoorah.
My name is Matt Reeder. I'm a law student at North Carolina Central University. Mr. Hafetz, I have a brief hypothetical and then a three-part question.
Like a law student, right?
Now I'm in trouble.
Let's imagine a young platoon commander operating out of Bagram Air Force Base or another U.S. firm base like it, who's tasked with capturing suspected terrorists, who's known to have trained at an Al-Qaeda training camp and is researching the use of poisons, but has never actually picked up a weapon against U.S. forces. My question, or my three-part question is, should Boumediene extend to give that individual constitutional rights if and when he is brought back to the firm base? If so, can you discuss the moral, tactical, and operational implications? And by that I mean moral implications that the platoon commander can choose to kill that suspect on the spot. Tactical implication meaning the platoon commander can try to question him there and risk his men. Operational implication in that if he does bring him back to the firm base, he's given those rights, it's a huge administrative drain on the system. If no, then why should the same terrorist, the same suspect, if he can procure a student visa to come to the United States, if he does receive a process, or he's granted due process under Hamdi and determined to be an enemy combatant, for lack of a better phrase, why then should he have an absolute right to be heard or access to federal forces?
There's a question from a Marine. Gentlemen, anyone want to tackle that one? John?
So I'm saying, in the first part, the person was picked up in Afghanistan, right? Is that right?
But
Yeah.
has never picked up a weapon.
Well, I mean, I think under Boumediene, it would depend whether he would get habeas rights, I think, depending on what process he'd been given by the military, how long he'd been held, right, at Bagram. I think it's clear, that there's, extensive U.S. control over Bagram. It's not quite the same as Guantanamo, but under Boumediene, it's very close. So I think it would depend under Boumediene on the process that that person received and how long he was held. If he was had been held for beyond a brief temporary period, had not been given any kind of fair process to test the allegations, I think that he would have then habeas habeas rights. So that's, I think, that answer will come out. I think that I think that's consistent with Boumediene. As to the second part of your the hypothetical question, which sounds awfully a lot like the Almari case. I mean, I think one thing is that of course the Constitution applies in full in the United States. So it's not just a question of the impracticable and anomalous test in Boumediene. This kind of test about which provisions apply under what circumstances. Like the whole document applies in full to people in the United States, and under the Constitution, you have a right if you're being detained on suspicion of wrongdoing to be charged and tried for that. I mean, as a non-citizen, you could also be detained under the immigration laws. So I think it would be unconstitutional, and as a statutory matter, I don't think that Congress has ever authorized that kind of detention. It didn't do it, in my view, in the AUMF. In fact, it took a contrary step in the Patriot Act, which was enacted at virtually the same time, and basically said you can't hold terrorism suspects for more than 7 days without charge. So I think it's a different situation. It's a different situation legally and as a policy matter, certainly from someone picked up in the country.
Any other questions? Yes, ma'am. Wait for the mic.
Thank you, and thank you for such a great panel. It's really been good. The question of whether we're at war is, I agree, something that needs to be addressed more fundamentally than the legal procedures questions. And I believe it was in the 1990s that Osama bin Laden publicly declared war on Crusaders and Jews. Then in 2001, obviously, Al-Qaeda killed a lot of innocent people. And from that, I draw the conclusion that I have enemies, which I knew already, okay? There are people who want to kill Americans, there are people who want to kill Jews. But the fact that I have enemies doesn't necessarily mean that I am at war. I know I was not at war in 2001 because Al-Qaeda is not an army. It's a bunch of nuts. Even if we were at war, even if we wanted to say, okay, well, that attack qualifies, you wouldn't fight it by sending 100,000 troops someplace. So regardless, really, of whether we decide to call it a war or not, it seems to me you think about who these people are and pick pick the method that fits your enemy to go after them. And if we did that and did it following our own moral precepts, the ones that the country has embodied in its text, a lot of these questions would not have come up, which is an easy way out. Thank you.
All right, well, let me add to your comment and throw it to the panel, because besides the fatwa that was issued by bin Laden, you also had the attacks on the embassy in Kenya and Tanzania in 1998.
Cole.
And you also had the attack of the USS Cole in 2000, which take it beyond mere rhetoric. So this is back to this question of, are we at war?
It's beyond rhetoric, definitely. But, yeah, but is it a...
No, I was just going to say, we want to get you on the record here.
Oh, wait, I would say one more thing.
All right.
Now, obviously, our military is at war, and their families are at war. But is it a war when again, these nuts or people with the crazy ideology manage to wreak this havoc? Because it sets off a nuclear bomb still. He's a nut.
Okay. Question in the back. Dusty?
Thank you, Scott. I'm Rear Admiral Dusty Miller, former Judge Advocate General of the Navy, and I compliment all four of you up there on this discussion. My feeling is the last question and what the commander has given us a good exposition on is really the question that we ought to be addressing, and that is whether or not the present rules are sufficient to address problems between the concept of war and the concept of law enforcement or peace. And let me just suggest that when the Military Commissions Act was enacted, it seemed to me that that was an effort to address problems in that interim, interregnum. And I compliment the commander on his suggestions for a national security court, which would differ, as I understand your concept, from the military commissions only significantly in that it would have civilian oversight, but would have still essentially the same rules. So I guess my comment and my question is, would this be an effort to address problems in that interregnum which would be helpful?
Glenn?
Admiral, thank you. I do think it would be. I think this is part of the system, would be for the existing detainees, but also future inevitable detainees, and including those at Bagram if we choose to use it in that fashion as well. And again, just going back to it, none of this can be done as one isolated initiative by the administration. It really has to be done in concert in the other areas we've spoken about, Admiral, like changing the name of the war, and I think, as the Colonel alluded to, having a conference to look at some of this ambiguities. We have to be doing these in concert rather than just doing them isolated or one at a time. In toto, they'll work efficiently and effectively to accomplish a lot of the problems. Done individually, I think we'll wind up hurting ourselves still and remain mired in this ambiguity.
Those of you that joined us at lunch yesterday for Congressman David Price, and I'm not necessarily endorsing his legislation, but he has in the House, in 3 different committees, all-encompassing legislative package which would run interrogation, detention, prosecution issues, indicating, again, I think what you're suggesting, Glenn, and Admiral, what you raise is you can't just fix the current problem. If you're going to create a new paradigm, it's got to be for the future as well. Did you have another? Bev's got the microphone for you, sir.
Thank you. I just wanted to ask Jonathan what his view on that problem is.
Pull the mic up.
Yeah, I mean, again, I mean, I think we have it's an opportunity now to really think, whether, do we need, another, another system? And I just, I think we just don't, the answer is no. I mean, I think that, we should, I think go back to, we've done it before and not have, I don't think we need new legislation. I think we need a national security court system. I think that, points I've made before, that the processes we've had in place are able to, not perfectly, but to meet the challenges pretty well.
Yes, sir.
Can I make a comment?
Oh, sure, John.
I share Jonathan's view, quite frankly, that we don't need something new, although I don't oppose what Glenn has suggested, because I think it has all the earmarks of a good system. The reason I don't think we need a new one is simply because it's not much. First of all, there's a lot of civilian oversight in the military commissions. There's an appeal to the Supreme Court. There are civilians in the prosecution function, civilians in the appointing authority, convening authorities function. The convening authority herself is a civilian, and there's civilians throughout the defense function. So there's lots of civilian oversight, first place. And there's 2 things that probably most people in this room may not know when they think about and form an opinion about detention and whether Gitmo should remain open and commissions under the Military Commissions Act. Not that spending money is a basis for, throwing more money after a situation, but if you're going to put people in the United States, you're going to have to build a new facility probably. And we've built 2 facilities down there, and we have spent over $500 million, over $500 million at Guantanamo, which is what the world doesn't know, and the reason the world doesn't know just what the quality of the structures are and that they're modeled on federal prison plans and so forth. And just to put that in context, because as Everett Dirksen said one time, $1 billion here and $1 billion there, and pretty soon you're talking real money. 1,000,000 seconds, 1,000,000 seconds is a little bit less than 12 days. And 1 billion seconds is almost 32 years. So we've spent $500 million at Guantanamo to make those facilities right. And the Military Commissions Act, unlike the proposal that was made within the Department of Defense in 2004, late 2004 and 2005, to simply modify the code so that there were some rough outline procedures for military commissions, just as Article 135 provides courts of inquiry procedures. The suggestion was on Article 135 Alpha for military commission procedures. This would have allowed, a task force commander in the Navy or the Coast Guard or anywhere in the world or on the coast of the East Horn of Africa or anywhere now or 30 years from now to ask back for the authority that had been withheld from him to conduct a military commission and go ahead and convene a military commission for something that happened, as somebody in this room just described about 10 minutes ago. Congress has taken a hand in this now, and that's what I fear for your proposal, is Congress is going to get involved. The Military Commissions Act applies only to the people at Gitmo. So they've restricted the UCMJ. The Uniform Code of Military Justice, been around since 1950, provided for military commissions. We've used military commissions starting in 1781 and in every war since then. And we were going to use them, and we weren't doing it very well, and we were doing it clumsily, and we were trying to change it and get it right. But now, Congress has intervened and given us something that applies only to Gitmo. It has nothing to do with anybody else in the world or 20 years from now. And I say that's a step backward.
All right, we got time for one more question.
Eric Jensen, U.S. Army.
I don't think that mic's on. Push the bottom.
Now
Yeah.
Eric Jensen, U.S. Army. I want to go back to something Glenn said, and that was that we're now in the process of providing more rights to some of these detainees than maybe POWs might have, or EPWs. It seems like Boumediene, along with the ICJ case in the Congo and the Wall case in Israel, are in the process of incentivizing people to become unprivileged belligerents, as opposed to incentivizing them to become belligerents and to make themselves known, to follow the requirements of becoming a combatant. And this seems a disturbing trend, and I just wonder if in the world of asymmetrical warfare, you find that disturbing as well. And then secondly, if we do either a national security court of some kind or Article 3 courts, let's say that we put KSM in this court and he gets 15 years, he serves his time, then what? Do we just release him like we do normal people when they come out of prison into the U.S. community and off they go, free to go? Or do we put them back in some kind of preventive detention, or what do we do with them then?
I'll take the second question first. If that's me. Respectfully. I think that's a great question, Eric. It's good to see you. I think the problem I would have with a civilian court, the way it's constructed now, the traditional Article 3 courts, is they would just, we know that, if he just gets 15 years or 7 years or 6 months as Hamdan got. Now, that's not likely with KSM, but it could happen. They would just go forward and go forth, and perhaps we're not sure where or how we would work the repatriation after incarceration. I think at the National Security Court, the goal is to set, if it is set up properly, again, there's flaws in anything. If it's not constructed properly, we'll have problems. If constructed appropriately, there is a strong imperative, a moral imperative, if you will, for the United States to ensure that once they are done, if this is set up where we know our national security needs have been protected in a greater sense than we would perhaps within a traditional Article 3 court, that when they've served their time, if it is 15 or 20 years, that we would be able to send them back, because the court, we would defer to the court's decision, the jury's decision, the judges, the national security judges' decisions as to where to go. The only thing I think that really comes up within a national security court system as well is we've sort of, if someone's been detained, not necessarily KSM, but perhaps someone has been detained for 7 years and was an Al-Qaeda member, one of the 50 or so we know was actively engaged in Al-Qaeda operations, that it's easy when we're done with them to try and convict them, perhaps. But what about the folks that we have right now that we are likely just going to repatriate, or folks that we have just a short period of time in prison that we're sending them back? I think we've sort of incurred a duty, if you will, a little bit to at least assist them in their repatriation back to their home countries, to their host countries. Right or wrong, if we have someone that we've been holding for 7 or 8 years, there is a sense that the U.S. has again, at least some semblance of a duty to ensure that they're taken care of and brought back into their system, whatever form or fashion is feasible.
We end where we began, with questions, no answers, but these are the issues that the new administration is going to have to deal with. Join me in thanking our panel. Okay, we're going to take a little less than a 15-minute break, but let's try and come on back in at 10:25.